Check 1, 2. We good? Are you okay?
Yes, we are hearing you.
Right. Good morning, everybody. Sorry, just trying to work out the logistics on sound and chairs and and also on the platform here. It is now 9:07. I'd like to call our meeting to order. I do see we have board members on the platform. But with that, Ms. Jones, would you please do a roll call to see to identify who's present this morning?
I will, yes. Good morning. Member Bitzer, can you hear us and are you present?
I am.
Okay, thank you. Member Carrasco? Member Curry?
Present.
Thank you. Good morning. Member Ely?
Present.
Member Garcia?
Here.
Member Honker?
I am present and I can hear.
Thank you. Chair Sweeney?
I'm here as well.
Very good. Let me loop back up. Member Carrasco, are you with us? I see you. You should be able to unmute yourself.
Present. Yes, sir. Yes, ma'am.
Okay. Thank
hear me?
you. Yes, we can hear you. Thank you. Chair Sweeney, you have a quorum.
Thank you so much, and good morning, fellow board members. Good to see everybody in person and online. With that, I'd like know the agenda. We have a draft agenda, and please take a look at it. And I'd love to entertain a motion so we can begin discussion.
I move we approve the agenda
Thank you,
for January 22nd.
Thank you, Member Garcia.
I'll second that.
Thank you, Member Ely. With that, are there any discussions, changes, revisions that fellow board members want to propose or talk about? Questions? If not, Ms. Jones, just let's do a roll call vote on the approval of the agenda.
Member Honker is indicating he might have a question or a comment.
Yes, Member Hunker.
The agenda looks fine, but I can't see anybody in the meeting room.
Okay,
okay.
give us a minute. A moment. We will take a look at that.
Can't remember how we set that up.
Thank you for that, Member Honker.
It just says upstairs.
Thank you, Member Hunker. I think I see that as well. Give us another minute and we will, Ms. Jones is checking on our camera. Good morning. We had some technical issues, but I think now, given we're gonna use my camera for the board members online. Can you see us? Okay. So we'll go off my, well, we need some drivers and stuff on the camera up in the upstairs. So we'll just go off mine. And talk to legal counsel Ugarte, and we can do a roll call. I can do the roll call for the record. But with that, Member Hunker, do you have any other comments, or it was just the camera? Is that correct?
No, sorry, I didn't mean to derail the meeting, but I can see you now.
Sounds good. All right. So with that, if there's no other amendments, revisions to the agenda, we have a motion on the table here by Member Garcia, a second by Member Ely. So I'll do a roll call vote. Member Carrasco, do you vote yet? Aye for approving the agenda? Can you hear us?
Aye.
Thank
Can you hear me
you.
now?
Yes, we can hear you now. Member Bitzer,
Yes.
thank you. Member Curry,
Yes.
Member Honker,
Yes?
Member Ely,
Yes?
Member Garcia,
Yes.
and I also vote yes. The motion is approved, and we have an approved agenda for our meeting this morning. With that, we'll go on to agenda item number 3, which is the approval of the January 8th through 9th, 2026 meeting minutes. And those were emailed out. I know here in the room we have hard copies. Love to entertain a motion to get this agenda item moving. Member Hunker?
Yes, I move we approve the minutes of the January 8 and 9, 2026 meeting.
Thank you.
I'll second that for the purpose of discussion.
Thank you, Member Bitzer. Appreciate it. And we have a motion to approve the meeting minutes and a second by Member Bitzer. Are there any comments, questions, revisions that fellow board members see on our meeting minutes?
Yeah, I've got a question.
Sure.
Is it just the one page? Because it looks like when I read down, it looked like it referenced the second hearing without actually having a second hearing or second day. So I'm guessing that it's just the one page.
Yes, it is just the one page.
That was my only concern.
Okay, so let's look at that. Which can you point me to the language that we were just we voted to continue deliberation? Is that think, is there any
You might-
revisions?
In my mind, that constituted the whole the whole of the 2 days. I just wasn't sure there wasn't a second page floating around that I didn't get. Sorry to just derail the motion here.
No. Yeah. No, I appreciate the comment, Member Bitzer. Yeah, so we just the meeting minutes were just documenting our discussion on the deliberations that we had, and that it noted that we'll have a continued deliberation. If you're good with that summary? All right, I see a thumbs up and some head nods. With that, I'll take a roll call vote. Member Carrasco, how do you vote on the approval of the meeting minutes?
I move to approve.
Okay. Member Bitzer?
I vote yes.
Okay. And Member Carrasco and Member Curry, since you weren't here for these, maybe we can just have you abstain since you weren't here for this meeting.
I'd like to change to abstain, please.
Thank you, Member Carrasco. Member Curry.
Abstain.
Thank you, Member Curry. Member Hunker, how do you vote?
Yes.
Member Ely?
Yes.
Member Garcia?
Yes.
And I also vote yes. Thank you so much, fellow board members. Appreciate your votes, and the motion passes. And we will go on to our next agenda item, and that is EIB 25-81R, petition to amend 20.4.1 NMAC and 20.4.3 NMAC of the hazardous waste regulations and to adopt 20.13.3 NMAC and request for hearing. And for this presentation, I believe we have counsel for NMED present. Thank you, and you can come up to the mic.
That should show you when you get there.
And thank you, legal counsel. The floor is yours.
Good morning, Madam Chair and members of the board. My name is Mark Roseborough, and I'm an Assistant General Counsel with the New Mexico Environment Department. With me today in the audience is Gregory Smithkier, my co-counsel, and John David Nance, who is the Bureau Chief of the Hazardous Waste Bureau of the New Mexico Environment Department. I'm here today on behalf of the Hazardous Waste Bureau of the New Mexico Environment Department to present its petition to amend parts 20.4.1 and 20.4.3 of the New Mexico Administrative Code. Additionally, I'm here on behalf of the department to present its petition to adopt proposed new rule 20.13.3 of the New Mexico Administrative Code, and hereby respectfully request a hearing before the Environmental Improvement Board beginning April 13, 2026. The petition seeks to implement 3 specific rulemaking actions, which I will address this morning. First, I will address the department's petition to adopt 20.13.3 NMAC. The petition to adopt a new rule at 20.13.3 NMAC derives from the Per and Polyfluoroalkyl Protection Act, which I will refer to as the PFAS Protection Act. The PFAS Protection Act was passed by the legislature and signed into law by the governor on April 8, 2025. The proposed new rules at 20.13.3 NMAC address the use of aqueous film forming foam, which is a firefighting foam that I will refer to as AFFF. As pertaining to AFFF, the PFAS Protection Act mandated that the Environmental Improvement Board shall implement 3 specific categories of rules. First, the PFAS Protection Act requires that the board shall implement rules which require a periodic inventory of AFFF quantities stored or used in New Mexico. Second, the PFAS Protection Act requires that the board shall implement rules which require the use of AFFF for emergency purposes only. Third, the PFAS Protection Act requires that the board shall implement rules which require the cleanup of discarded AFFF pursuant to the New Mexico Hazardous Waste Act. In accordance with the legislature's mandate and the PFAS Protection Act, the department has submitted a rule satisfying those requirements. As for the amendments to existing rules, the petition seeks to amend 20.4.1 NMAC for 2 reasons: to comply with recent legislative amendments to the New Mexico Hazardous Waste Act, and to make changes necessary to support the federal reauthorization of New Mexico's hazardous waste program and regulations. On April 8, 2025, the New Mexico legislature passed House Bill 140, which was signed into law by the governor. House Bill 140 amended the Hazardous Waste Act by including discarded AFFF containing intentionally added PFAS in the definition of hazardous waste. House Bill 140 further amended the Hazardous Waste Act to give this board the power to adopt rules under the Hazardous Waste Act pertaining to AFFF containing intentionally added PFAS. The department, via its petition and proposed amendments, seeks to amend 20.4.1 NMAC to make its regulations consistent with House Bill 140's statutory revisions to the Hazardous Waste Act. The remainder of the amendments to 20.4.1 NMAC are necessary to support the department's efforts to obtain federal reauthorization of its hazardous waste program and regulations. Hazardous wastes are federally regulated by the Resource Conservation and Recovery Act. However, states may obtain federal authorization to administer state hazardous waste programs by complying with the requirements outlined in 40 CFR Part 271. Since 1985, New Mexico has administered its own hazardous waste program pursuant to the authorization authority granted by the United States Environmental Protection Agency. Under the New Mexico Hazardous Waste Act, the New Mexico legislature mandated that this board shall adopt rules for the management of hazardous waste as may be necessary to protect public health and the environment that are equivalent to and at least as stringent as federal regulations adopted by the EPA pursuant to the Resource Conservation and Recovery Act. It is this authority and mandate of the board that the department invokes in its proposed reauthorization amendments, which are necessary for the federal reauthorization of the department's hazardous waste program. On October 31st, 2025, the department published public notices number 2507 and 2508, outlining the proposed revisions to 20.4.1 NMAC. The public notices encourage the public and interested stakeholders to contact the department with concerns or questions about the amendments to 20.4.1. The department used stakeholder feedback to draft portions of the amendments to 20.4.1 that are attached to the petition. Finally, the department seeks to amend 20.4.3 NMAC to correct a typographical error in the existing language. As currently drafted, the fee language in 20.4.3.202C refers readers to 20.4.3.401. The department seeks to revise this provision to refer readers to 20.4.3.201, which was the intended reference provision. Should the board grant a hearing in this matter, the department is prepared to establish that the proposed new rule at 20.13.3 NMAC and the amendments to 20.4.1 NMAC are justified and in the public interest given the impact to human health and the environment caused by AFFF containing intentionally added PFAS. The department is further prepared to establish that the proposed amendments to 20.4.1 NMAC are justified and in the public interest given the environmental damage and injury to human health and property which would be caused by the state's inability to administer its own hazardous waste program. Furthermore, the department is prepared to establish that the amendment to 20.4.3 NMAC is justified and in the public interest given the confusion caused by the existing typographical error. In addition to the statutory authorities previously mentioned, the board is authorized to adopt regulations pursuant to the Environmental Improvement Act and 20.1.1 NMAC. For these reasons, the department respectfully requests that the board authorize a hearing to consider the merits of the petition to begin on April 13, 2026, and appoint hearing officer Felicia Orth to conduct the hearing. Ms. Orth has confirmed that she is available to conduct a hearing in this matter the week of April 13, 2026, if the board chose to appoint her. Regarding the length of the hearing, the department anticipates it needs no more than 2 days to present its evidence in this matter. I'll note that in our petition, we requested 5 days, being unsure of the public interest in this. And so I'll leave it to the board, should our petition be granted and request for hearing be granted, to determine how much more time in addition to 2 days would be necessary for a hearing of this matter. With that, I thank you for your time and I'm happy to answer any questions that the board may have.
Thank you so much for being here today and your presentation. Fellow board members, do you have any questions? Yes, Member Garcia.
Thank you, sir, for your presentation. In your petition, of course, you did ask for 5 days, and I'm not clear why you backed off and thought maybe 2. Did you get a feel for how controversial it is, or do you know of some of the parties that might be opposed to this? If you could let us know how much opposition there might be to this rule.
Good question, Member Garcia. We have received very little negative feedback to the proposed rule. I mentioned in my presentation that in response to public feedback, we revised a portion of 20.4.1, and we did that in response to the public comment. Given that no parties have entered their appearance in this matter so far, which of course is not required, we are not anticipating robust public opposition to this rule. Of course, we won't know for sure until the final deadline passes to participate. But we've received less public pushback than we were anticipating could come at the time the petition was filed in December.
Okay, thank you. That's helpful.
Thank you, Member Garcia. And I just want to do a double check. So, Ms. Jones, there's no parties to this petition, or? Okay.
Oh, I apologize for that error.
I just wanted to make sure that that was, that I understood that correctly. Any other board members have questions? Those online, I don't see anybody raising any hands. So fellow board members, I don't have any questions about the petition. Do you want to discuss whether or not look at our calendars and different aspects of the request by NMED? So if you could take a look at your calendars and see if you are available for April 13th. And I just want to double check if Madam Hearing Officer Orth is available.
She is.
Okay, and Ms. Jones is indicating she is available.
Chair Sweeney, I just want to note that Mr. Weatherby is indicating he's requested to speak.
Okay, thank you so much for that. Yes, Mr. Weatherby. Thank you for.
Thank you very much. Thank you very much, Madam Chairwoman. And this is more in lines with the question. I did file an entry of appearance, and it was for informational purposes, so me and other colleagues in the media can report on a very important issue here. I am concerned about the number of days that were raised. Given the importance of this measure, it's moving along quickly, which I understand the need for it to, but is there ample opportunity to involve the communities that obviously have been affected by this? Obviously, people that live in areas that are affected by fires are put in a position where they need to get the fire out, and then there are problems with the obviously with the contamination that occurs as a result of putting a fire out. And I'm wondering, given the enormous amount of money that goes into replenishing water supplies and protecting water and such, how much of a communication there has been with those communities that are located in various parts of the state. And this seems to me like it may just be as much as it's needed to be done, it may be moving a little too fast, even though it needs to be done yesterday. So that was mostly my observation. I appreciate the department's efforts on this. I know this is really important, and thank you.
Thank you, Mr. Weatherby, for your comments this morning. I appreciate those. And maybe, one other question I think and normally we ask this whenever petitions come, requests of to the board, is what kind of public engagement? I think Member Garcia was kind of getting at that as well, and what kind of outreach has been done by the department? If you can elaborate a little bit.
Yeah, just to respond specifically to Mr. Weatherby's concerns, it's my understanding that AFFF, what we're regulating with these proposed rules, is different than fire retardant, which is used by federal agencies like the U.S. Forest Service. So different products, different regulatory process. That being said, we have issued 2 public notices. Of course, we're going to issue a notice of hearing, engage in tribal consultation and small business consultation, and all other consultations required by the State Rules Act going forward. But to date, what we have done is issued the 2 public notices, which were issued in October, have been live and remain live on the NMED's Hazardous Waste Bureau website.
Thank you so much for that response. Is there any other follow-up questions? Yes, Member Ely?
On a slightly different topic, did HB 140 have a date by which the board had to adopt rules?
No, no, Member Ely. The reason why we want to move so quickly is because of the very serious threat that the use of AFFF poses to Mexico's environment and its people and property. You know, we've seen the results of what's happened near Air Force installations across New Mexico, and this is a priority of the department to get this rule implemented.
Thank you. All right. With that, fellow board members, given the presentation and some of the follow-up comments, what are your thoughts about the date, accepting the petition, and any other logistics associated with this request? Yes, Member Ely?
Well, I think we should move forward with the petition. I agree that it's an issue that needs to be addressed, and those dates work for me.
Thank you. Was there, yes, Member Bitzer?
Dates work for me. I agree that there's urgency here. Question for council, maybe he's not the right person to answer this, but is this AFFF the stuff that forced the cattle guy down in Clovis to put down 500 head of cattle because of the contamination in the water?
Yes, Member Bitzer, it is.
Yeah. Some serious stuff. We should move with all due speed.
Thank you, Member Bitzer. With that, I'd love to entertain a motion. If there's further discussion, then we can have it after we have a motion on the floor. Yes, Member Garcia?
Yes, thank you. I also agree to approve the petition for hearing, and those dates work for me. I can move some things around. So if we're ready for a motion, I would move that we hold a hearing the week of April 13th, set it for 2 days to be continued if necessary for EIB 25-81.
Thank you, Member Garcia. Do I have a second?
I'll second.
All right, Member Ely seconds. With that, are there any further discussions? I think hearing officer.
I forgot to
Yeah, we just.
I would amend my motion to include appointing Felicia Orth as the hearing officer for the hearing for EIB 25-81.
Yes, legal
Sure.
counsel.
One final logistical thing that I'm not sure needs to be moved on, but I'll raise it in case, is our deadline to file the notice of public hearing would be next Thursday to give the public 60 days notice. We have to get the Spanish translation done. We'd like to get that, started today if we can. I understand we typically, or the board typically holds hearings at the Capitol. I believe the legislative session will be done by then. And maybe Ms. Jones needs to look into this later this afternoon, but the sooner we could set a location, the better, so that we can get the translation concluded and shipped off to the New Mexico Register by next Thursday.
Thank you. Mitch Jones?
If I could comment on that, a lot of our public notices direct members of the public to look at the NMED calendar, which will have the actual date, the location in the event we can't get it set. There's always a possibility that they change it on us too. So that might be a suggestion for you.
Okay. I'll defer to the board. I just wanted to raise that for your consideration.
Appreciate that. Yes, Member Bitzer.
Maybe I misunderstood the motion. Did we just say 2 days or 5 days? I thought we were going to go with the 5 days for the abundance of caution in case this becomes a big deal.
Thank you, Member Bitzer. Member Garcia.
Thank you, Member Bitzer.
Message has been transcribed. One moment while I notify the caller.
Give us a minute here.
Mute the call-in. It's hard to do when okay. Sorry about that.
Thank you, Ms. Jones. Member Garcia?
Thank you. Thank you, Member Bitzer. My motion is for 2 days based on the petitioner's verbal revision of their request, because they have had very little pushback, and so they're anticipating that 2 days would be adequate. However, I did note in my motion that if more time is necessary, it can be continued as necessary.
I guess my follow-up is that a question would be to council, is that legally adequate to have a 5-day hearing if we need it?
Member Bitzer, yes, I think that's fine.
Thank you. Thank you for that clarification, Member Bitzer. Those are some of the questions I also had, so I appreciate that. With the motion on the floor, legal counsel, are we sufficient in our motion?
Yes, Madam Chair.
All right. Is there any other discussion or points of clarity that anyone, the logistics, normally Ms. Jones is able to support the board on the logistics, but if there's any other points that we need to consider in the motion, please let us know.
No, Madam Chair. Thank you.
Thank you. With that, Ms. Jones, seeing no other questions or revisions, Ms. Jones, please do a roll call vote on Member Garcia's motion.
Member Bitzer, how do you vote?
I vote yes.
Member Carrasco?
I vote yes.
Member Curry?
Vote yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Chair Sweeney?
Yes.
The motion passes.
Thank you, Ms. Jones. And thank you to NMED for presenting this morning our agenda item number 4, EIB 25-81. Look forward to seeing you here in the near future. Thank you. And thank you, Mr. Weatherby, for your comments as well this morning on agenda item number 4. With that, we will go on to agenda item number 5, EIB 25-23R, which we have the continued deliberation in the matter of proposed adoption of 20.2.92 NMAC Clean Transportation Field Program. With this, I'd like to take a 10-minute break and make sure that we have logistics here worked out as we enter deliberations. Again, thank you. So we'll come back at, let's say 9:55. Good morning, everybody. Sorry, we're still working some technical issues here. That said, I think we're ready to get started with our deliberations. You're good. That's your. We are on agenda item number 5, EIB 25-23. And I just want to, yes, Ms. Jones. Ask Member Honker, Member Bitzer, can you see us, or should we have a owl device here that you might be able to see us better? Do you want us to try that? Yeah, they want to. So we'll take a few more minutes to or can you see us okay? Sorry. We're good? Oh, okay. They said we're good. Okay. All right. And we'll maybe if the meeting continues, we'll figure that out. When we have another break. Thank you so much for getting that. All right. I think we're good. Ms. Jones, on mine, I can see Member Bitzer's camera, but on that one, I cannot. Is there? Yes. He has his camera on. It might be bandwidth. Okay. There we are. Okay. Thank you so much. All right. I know we're continuing deliberations in the matter of proposed adoption of 20.2.92 NMAC. And see, and we have our Madam Hearing Officer, Miss Orth. Just doing a quick check that we can hear you, Miss Orth. Can you just do a quick sound check to make sure?
Can you hear me, ma'am?
Yes. Thank you, Miss
All right.
Orth.
عليكم السلام ورحمة الله وبركاته بابا.
Who is that, Miss Jones? Oh, that's Mr. Bitzer. Okay. I don't see it coming from Mr. Bitzer on my platform.
It's the translator. It's the Spanish translator.
Oh, okay. There it is. You got it. Miss Jones, it was that one that you just muted. All right. I think we got all the sound. I apologize. Thank you, board, for bearing with us this morning. Let's get back to it here. Fellow board members, it's all right. And as we continue here, I want to make sure that I'm on the same page, literally, that we've been using our tracking version. And just checking with fellow board members, I think we were in 600 section 604. Yes, let me zoom there. I just wanted to verify with, I know, Member Carrasco and Member Curry. I know, I understood that for this agenda item, you had not been participating in the deliberations for EIB 25-23. So I just want to make sure that we have clarity. If you want, we can message you when we're done with this and you can come back on. Would that work for you all?
It's fine with me. Just send me a text.
That would work for me as well.
Thank you, Member Curry and Member Carrasco. We'll do that for you. So right now it'll we will just be talking about agenda item number 5, which is the deliberations. I just want to make sure that we all were on the same page. Thank you so much. All right, with that, sorry, I'm still scrolling to 604.
Page 162.
162, okay.
My paper copy.
Okay. All right, fellow board members, so we're on page 162 on our tracking version, or what we've referred to as our multicolored tracking version of the rule. Let me make sure, and I know we ended our discussion last time on some of the Okay, and we are on enforcement, and we were gonna look at the language regarding this section to see if we could revise it to address the concerns and the items that we had talked about. So I just want to reground us, and Member Garcia, do you have a comment?
Thank you. Just to, if we can ask the hearing officer to verify what we did just as we ended last time. My memory is that we struck 604C, the compliance order. So where we would start today would be D on page 164. Is that right?
Member Garcia, thank you for your question. So, am I coming through the mic?
Yes.
Okay. So on January 9th, at the end of the day, the last item the board concluded was they'd taken an interim vote on striking the language in subparagraph C of section 604. The board began looking at subsection D, recognized some complications due to the striking of C, and then decided to take a break given the hour, and we had to be out of the building at 5. And that's where we concluded.
Thank you. Thank you, Legal Counsel Agarte. Does that help, Member Garcia?
Yes, thank you.
Member Ely, sorry, I saw you reaching for your mic.
Yeah, and one of the things we were talking about is potentially adding new language regarding canceling or revoking credits and potentially making some edits to address that issue. I did work a little bit on that yesterday afternoon, and then I got this email from our administrator, Pam, with some of the responses to the hearing officer's request to provide more information on potential unintended consequences with some of the proposed changes we were making. And that came yesterday afternoon at 3:05. So I stopped, and because I think some of the proposed language by the department on how to address some of those issues is better than what I could have come up with. And so I think that a new section C as proposed by the department would be something to consider right now.
Thank you, Member Ely. And I just want to look at and verify that how we integrate or how we not integrate, how we address some of the our work and homework since we left the deliberation. Legal Counsel Agarte, how would we, to Member Ely's point, come up with language? Could we use that? Some of the information that was emailed, can we have some guidance on that?
Thank you, Madam Chair. I think I recognize that there were materials submitted to the board, and in my view, I think the board was on the right track when they were deliberating a few weeks ago. Again, I watched the video, the end of the video, and saw that when the board started looking at subparagraph D, the board recognized, and with help from hearing officer Orth, that the language, if striking C stays, D would have to be revised because D has language that's referred in C. So I think that's why the board stopped, because then it was going to take a little bit of time to go through D, understand the consequences of striking C, and maybe revisit C. And that's, I think the board, given the experience, and this is really the hard task, I think, before the board is, all right, how do we make sense of this? How do we figure out, given your experience, your background as regulators, to make this work? And so I think you were on the right track before the submissions. there's nothing new in the submissions. It's pointing to what was already in the record. So it can aid the process. But in the end, I think ultimately the board is being asked to utilize your regulatory experience to figure out what's the best way to work on this. And certainly we're available for help. But that's what I think the task is. Is that helpful, Madam Chair?
Yes. Yes, thank you, legal counsel. Fellow board members, is that discussion helpful? I just want to make sure that we're clear, given the complexity and timelines and deadlines. And also, and that reminds me, legal counsel Ugarte and fellow board members, with that question, I just want to check in with also Madam Hearing Officer Orth. I think there was something that making sure that we didn't miss anything administratively that we might need to address before diving back into working on the language itself. Ms. Orth? You're on mute. Give us a moment. Ms. Jones is troubleshooting a sound.
Okay, now it
There-
says I can unmute myself.
Yes, we can hear you now.
All right, thank you. So I think Mr. Ugarte is correct in everything that he said. I believe you were forwarded everything that all of the parties submitted. There was a submission from CCAE, submission from Namoga API, submission from Sinclair, submission from the department. And the understanding, of course, was that any board member might rely on any of those submissions to say, I want to revisit a particular topic or a particular decision, preliminary decision that was made, because they're all preliminary until you get to the final vote. So I believe you have what you need in order to revisit what you would like to revisit. And I did not see new evidence being submitted. Certainly some argument around unintended consequences and other argument, but I don't believe we need to make any decisions around new evidence or evidence coming in outside of the record.
Thank you, Ms. Orth. I appreciate those comments. Yes, Member Ely.
Procedurally, there were a couple motions that came in. Do we need to make any decisions on those?
Yes, legal counsel Grote.
Member Ely. My understanding is that the motions were filed. The parties will have an opportunity to respond to the motions, and then there'll be replies to the motion. So that motion practice has to run its course, and that hasn't happened yet.
Thank you, legal counsel Garte. So that, yes, Member Hunker.
Yeah, looking at my notes, that there was one slight difference. I thought we were okay with 604D. I thought it was 604E where we started seeing conflicts. Since D is civil action, I didn't think there were issues regarding that section. Just that was my recollection and my notes from the last time we discussed this.
Member Hunker, you're correct. I apologize. The board had moved to E. There was no party had contested D. And it stopped in the middle of the discussion of subparagraph E.
Yes, thank you. Member Garcia?
I guess the only issue is that in D, there's a reference to enforcement of a compliance order. And we struck that compliance order provision, so that might need to be amended.
Madam Garcia, you're correct. And so to the extent, as we were reminded by hearing Officer Orth, the actions or the process that the board has followed to this point in the deliberations have all been preliminary. At the end, the board will take a vote on what the rule will look like. So to the extent you're going through 604C, you make a decision, you go to D and you realize, oh, we may have to revisit that or revise D as a consequence. That's part of the process.
Thank you, Legal Counsel Agarte. So for that, for your point, Member Garcia, let's go back and look at C just to verify that we don't need to address anything in C. Is that amenable to the board? Okay. And sorry to go backwards a little bit, but I just want to make sure that we address all of the details given as legal counsel Ugarte mentioned that we need to, that might happen. Just, and again, just going through the fine details of this role. So with that, with any other, I think, fellow board members, are you comfortable going forward, having addressed some of the correspondence back in, that we received, some of the motions? Are you comfortable going forward at this point? Yes, I see a yes in the room. How about those online? All right. Member Bitzer, do you have any other questions or comments? Oh, thumbs up. Okay, wonderful. All right. And so we will go back to 604C. And let's take another look at that and see if there's any anything we want to address and discuss. Yes, Member Ely?
At the end of the day on the 9th, we started talking about a little bit about the consequences of eliminating paragraph 2, A through E, and had just a very brief discussion about would it be possible to move some of that language into another part of the rule so that we have strong credit and deficit calculations at the end of the day. Because if we don't have that, I don't think we have much of a program. You have to know who is a creditor, who has deficits, and make sure that those are real credits and real deficits. And so in looking at paragraph 2, there was a brief discussion about potentially moving some of that language down into E. I thought it made more sense to move some of that language into the notice of compliance so that the department, if there was an enforcement action, they could do all the things into suspend, restrict, modify, or revoke an account, suspend, restrict, invalidate, or cancel credits. Those are really important functions of the department in an enforcement action. Yesterday afternoon, we got a proposal to look at CCAE Exhibit 4A, and that went out to everybody. Hopefully everybody has that language in front of them. And what they're proposing, instead of making modifications to D or E, to make a new section, 604C, not a compliance order, because we've all agreed, I think, that a compliance order is not authorized under the enabling statute, but new language under corrective actions, a new C called corrective actions, that gives the department the authority to do all of those things, to suspend, restrict, modify, or revoke an account, suspend, modify, or delete an approved alternative pathway, suspend, restrict, invalidate, or cancel credits, recalculate deficits, or assign deficits as an administrative mechanism in the event invalidated credits cannot be canceled, assess reasonable costs for the enforcement action, and then 6, an action the department has authorized elsewhere. They can take corrective action. So anyways, in my mind, that's where a good part of the discussion should go today, to try and address these issues to make sure we have a real market with valid credits, with deficits that can be addressed.
Thank you, Member Ely. Any other comments, board members? Yes, Member Hunker.
Yeah, I agree with Member Ely. I think the alternative of putting the corrective actions language in where section C was is a good thing to bridge missing authorities and procedures there. So I agree that that's language worth considering by us.
Thank you, Member Hunker. Yes, Member Ely.
Do all the board members have that language in front of them?
Yes, can you just reiterate so that we make sure we're all on the same page, given we have some virtually and some in the...
So the language comes from CCAE Exhibit 4A that was presented during the direct testimony. And it's 604C on page 83 of that exhibit. Now, that language was lifted and put into the document that was submitted by the department on January 15th that the board got yesterday afternoon, and it's on the very last page. So if you haven't looked up CCAE Exhibit 4A, you can pull up the document that was sent at 3:05 yesterday and look on the very last page to see what that language looks like.
Thank you, Member Ely, for pointing us to the exhibits in the record. Again, to verify that this is not new information, just pointing us to the record. Fellow board members, do you see the language in that board member Ely is pointing to? All right. Okay, let's look at that language. If that's amenable to the board, I see a head nods on our side and on the platform. Any thoughts regarding this language for section 604C? Yes, Member Garcia.
I agree. This is a good area to discuss, and it's a good place to start. I guess one of the first questions to get answered would be if we do agree a new section C, or do we put some language from the suggestion into part B, which is the notice of noncompliance, because that's the new verbiage. Well, not new, but the verbiage we'd be talking about. So it seems like it would fit under notice of noncompliance part B, but I'm open to other suggestions.
Thank you for your comments, Member Garcia. Board members, what are your thoughts about that suggestion? Yes, Member Ely.
Well, actually crafted language to change B to include some of this. But I like this better. I like having a separate section under corrective actions. I just want to note there's a lot of references to 604 at the beginning of the document and through the document. Fortunately, it just says section 604. It doesn't say which paragraph or subparagraph it is. So So it could be either way and still work with what's earlier in the document.
Thank you for those comments, Member Ely. So if I can absorb it in my brain, and I'm going to reiterate. So it'd be looking at keeping a section C with the language revised in section C, which initially, as the initial department's proposal was C compliance order, to, is it to all or portions of correct, and a new title, corrective actions, and then what was in CCAE's proposal? Is that okay? So the C corrective actions, when on the basis of any information, all the way to 1, 2, 3, 4, 5, 6, be the new, or proposing that to be the new C. Okay. Yes. All right. Yes, Member Garcia.
Yes, thank you. And I'm not opposed to creating a new C, corrective actions. And I think the language works except for item number 5, which we decided was not supported by the statute.
Did we have that discussion?
Well, let's make sure that we've addressed that. Yes, Member Ely.
Yeah, I'm not, did we have a discussion on item 5? I know we opted to eliminate all of section C. I don't know that we had a particular discussion about whether the department has the authority to assess the reasonable costs not accounted for in the annual CTFP budget for the department's expense of investigating and pursuing a violation or non-compliance. I don't recall having that discussion. I just remember saying ACOs were not allowed under the statute for this program.
Thank you, Member Ely. Member Garcia.
Yes, you're right. We didn't discuss it in depth. We simply eliminated it by eliminating section C. It would have been page 163E. And since it was eliminated already, we could put it back in. I do have a problem with it. I don't know of any regulatory agency that has ever, and I could be, wrong, absolutely, but I don't know of any regulatory agency that has assessed cost to an entity for the expense of investigating and pursuing a violation. And perhaps, Madam Hearing Officer, could, with all your vast experience, if you could correct me if I'm wrong, if there's I've never seen this before. I'm not sure that that it's allowed to do something like this.
Let's see. Member Garcia, as I understand it, the department has taken the position that they do have the authority to impose these costs, and that position, so far as I know, has not been tested in the courts.
Thank you, Madam Hearing Officer, for your response. Also look to Legal Counsel Garte if you have any thoughts on this this question.
Thank you, Madam Chair. I think this may be a good point to remind the board that the board is not being asked to make legal determinations. So, whether something has a statutory basis, that's a legal determination. And the board is tasked with developing a cohesive rule and giving your technical experience. I think that's the focus. So hopefully that's helpful.
Thank you, Legal Counsel Ugarte. And I know in the proposed, the proposal by NMED, they noted an enabling statute, 20.2.92.604 C2E NMAC. Oh, of this rule. Okay, let's see. Let's look at that. Yeah. Do you have a comment, Member Ely?
So in the enabling statute, 74.1-18, C10, it says that the Transportation Fuel Standard Program rules shall establish fees for the cost of the department's administration and enforcement of the program, provided that any fees are deposited in the State Air Quality Permit Fund. And so that's the language I think they're pointing to that says they have the authority to go back and not collect fees up front for enforcement, but to essentially invoice the company for the department's investigation if the costs go beyond what's already in the budget. That isn't a novel, maybe I shouldn't say novel, a new way, I think, of assessing fees for enforcement. And it's not consistent with what the department has done previously. And I don't know of any other agencies that have done it this way. Now, it's not an I believe that fees should be collected up front, that the company should know what their obligation is going to be up front and not necessarily after the fact. So I'm not real supportive of that language in paragraph 5 in C5 that we're looking at.
Thank you, Member Ely, and I appreciate that reference. I read that sentence wrong, but in looking at the actual statute, so I appreciate that. And yes, Member Hunker.
Yeah, when I read that, I immediately, the question popped into my mind, what's the vehicle for assessing these costs? Is it the fee program? I mean, normally, if you had compliance orders and administrative penalties, you could roll it into that. But without that vehicle, it's got to go somewhere else. And I would think Member Ely's right. It would be rolled into the fees, but it sounds like it would be a separate action. You know, here's some additional fee amount for you to pay, which seems a little unusual in my experience.
Thank you, Member Hunker. Member Garcia?
Yes, I note that the department made the argument that this way entities that are in compliance wouldn't be burdened with extra cost if they raise the fees because of a bad actor. However, the way every other regulatory agency I've ever worked for, that's just the way it goes. And they have to, the department pays for the cost of enforcement for the bad actors. And it's part of the cost is the Bureau itself, part of the cost is the entire department, indirect cost, et cetera. And breaking those up into what they, you know, I just don't know how this would be done. I'm not in favor of that section of the, I think everything else looks fine, but item 5, I just kind of get stuck in my craw a little bit.
Thank you, Member Garcia. So what I'm hearing from fellow board members is section C, corrective action minus the proposed corrective in the CCA language minus item number 5. Is that what I'm hearing? Okay. Just wanted to make sure. Is there any other amendments to this language as proposed by CCAE exhibit? All right. Okay. I think we're, and please correct me if I'm wrong, board, if there's other elements that we need to discuss, please feel free to raise your hand. But it seems to me that we're at a place where we could have a motion. Yes, Member Ely?
I move that we include a new paragraph 20.2.92.604C, corrective action that from CCAE Exhibit 4A minus paragraph, or is that subparagraph 5.
I
I'll
second that.
second that.
Okay, Member Garcia beat to Member Hunker to the button here. But with that, just thumbs up if we're good with that. If you feel comfortable, yes, I see a thumbs up from Member Bitzer, Member Hunker, Member Ely, Member Garcia. Are you comfortable? Yes. All right. So we this section 604C to be revised to the language in CCAE's proposal. And so that takes us to 604D, back to where we started in D. Do you have any comments, board? This language? Yes, Member Ely?
Noting Member Garcia's suggestion that we should address the issue of a compliance order in there. So D is civil action. If we're eliminating compliance orders in the rule, then that needs to be addressed. Also, the CCAE language, again from CCAE Exhibit 4A, proposes adding to this paragraph that the department shall provide written notice to the person that it is the subject of the corrective action.
Thank you, Member Ely.
So the fix on that, I think, is to change compliance order to notice of noncompliance, and then add that sentence 604D that was proposed by CCA to this paragraph.
Thank you, Member Ely. Member Garcia.
Yes, I think that would work. I also see that the very last sentence, collection of an assessed civil penalty cost or fees. So cost would have to be addressed as well. Perhaps just eliminated.
So the discussion is to eliminate the word and just have civil penalty or fees. Is that?
Yes.
Okay. So in, and then to address Member Ely's comment, going back to CCAE's Exhibit 4A, the department shall provide written notice to the person that is the subject of the corrective action, to add that language as well. Any discussion on these, this language that we are, I guess, updating, revising based upon the exhibits? And this would again be under 604D as in dog. Yes, Member Hunker?
It seems to me that the sentence, the department shall provide written notice to the person that is the subject of the corrective action would go better at the end of section C, our new section C on corrective actions.
Yes, thank you. Yes, Member Ely?
I believe that that sentence pertains to civil action. So they need to get written notice that they are subject to a civil action by the department. So not the notices of non-compliance, but they need written notification that they are subject to a civil action, which is why it would go there. Yeah.
Thank you, Member Garcia?
Thank you. Yeah, I was a little confused by that too, Member Honker, because if you're taking a civil action in court, aren't all the parties notified? Council Ugarte, I mean, it would be nice for them to send a letter saying we're taking you to court, but could you address that, please?
Member Garcia, you're correct. If you're party to a civil action, you are provided notice.
Yes, Member Hunker, I saw your hand up.
Well, before that comment, I was going to say, well, maybe it should be, we should change corrective action to civil action, but that may be redundant based on what council just said.
Thank you for that comment. Yes, Member Ely?
So that by taking out ACOs, you have a notice of noncompliance and you have a civil action, two separate things. And as we just discussed, that those corrective actions go back to B, which is notice of noncompliance. So all those items that we just talked about are not necessarily moved forward under civil. They go back to section B. So I just want to reiterate that I think, we have those two tools. We have notice of corrective action and we have civil actions. We don't have the intermediate ACO. And the way that the language is now, it keeps those two items separate, which is, I think, as it should be.
Thank you for that comment, Member Ely. Yes, Member Garcia.
So why wouldn't we put it under C?
Yes, Member Ely.
Because B already says that they will receive a notice of noncompliance. And then C is when they get that notice of noncompliance, if the department, in addition to issuing that notice of noncompliance, has the authority to do all the things that are in C. And if they're still in noncompliance and they're still not following the rules as they should, then they go to civil action. And it's under civil action where they would go to court and at that point, they should get written notice, but potentially the courts will send them written notice that they are being sued in the district court. Does that make sense? Please, counsel. I'm not a lawyer. Please help me with this. Yeah.
Yes, thank you. Legal Counselor Garte, I keep going back and forth between B, C, and D, making sure that we're comprehensive and covered in all the elements of those sections.
Thank you, Madam Chair, Member Ely. So walking through the rule as it stands at this moment, in B, the department may issue a notice of noncompliance. So any regulated party would be on notice if anything under B was taking place. Then C, as you've just adopted whatever was in the CCAE exhibit, I don't see any notice language in that, in the revised C. And when I look at what was proposed in the sentence that you've been focusing on, it seems to me that that sentence belongs, because it does refer to a corrective action in C, because as we discussed earlier, if there's a civil action, everybody knows about it. If you're a party, you're going to get noticed, served. So I don't see any notice. So you would think that if the department is taking any action in one, suspend, restrict, modify, revoke, there'd be some kind of communication. So it's sort of presumed in that, and maybe that sentence is not needed. But if anything, I think it's missing in C.
Thank you, Legal Counsel Garte. Yes, Member Honker.
And I agree totally with Council Ugarte. It seems like the missing notice would be on all these actions in our new corrective action C. I mean, the regulated party needs to be aware that those actions are taken. So it would be appropriate to add it to that section.
Thank you, Member Honker. So what I'm hearing is the proposed language by CCAE, Exhibit 4A, the department, which initially is D, but the language being the department shall provide written notice to the person that is a subject of the corrective action, and that go up to Section C. Is that what I'm hearing? Member Garcia.
To me, that's where it makes the most sense. I'm not sure how it would be numbered. Whether it would be a different D and then we would change the other D. I'm not sure. And but yeah, to me, that's where we're talking about corrective actions. And so that's where they should send out a letter to the regulated entity.
Thank you. Any thoughts of where, I'm looking at the language now. So really we have 1 through 5 because we took out the proposed language by on item 5. So we have 6. Yes, Member Ely.
CCAE's exhibit has it as a separate paragraph. So it has C, corrective action, and then it has D with that language in it.
So we could just keep it as D and then look at it. Okay. Okay.
Yeah, so we could keep it as D and then just change the lettering.
Member Honker.
Well, I also think it could just be added to the end of current section C, not as a subsection, but go back to the same indent on the paragraph above it as another section. I mean, another statement that's in the overall section.
So looking at C, our new C dot corrective actions, and then we have the main paragraph starting when on the basis of any information. So you're saying another clause that's not 1 through 5, but just another.
Yeah, go back to the paragraph at the end of 5. I mean, those are all modifying, take the following corrective actions, 1, 2, 3, 4, 5, and then go back to the paragraph with the written notice sentence.
Member Garcia?
Thank you, Member Honker. I'm not sure I'm clear on what you're suggesting. Are you saying to go into the first paragraph, corrective actions, where it stops, take the following, and then put it there, or are you saying, I'm not quite clear of what you're suggesting.
I would just put it on the end, and it's not a subparagraph. I mean, it's just part of the above paragraph, but it applies to all those things. Or we could go with a new D and re-letter the other 2 sections.
Thank you, Member Hunker. Sorry if I cut you off. All right, Legal Counsel Agarte, do you have some thoughts?
Thank you, Madam Chair. So one option, if I'm understanding Member Honker, Member Garcia, I think, so I'm looking at the new paragraph C, and that towards the end, it says that taken under section B of this section, and it could just be comma, something to the effect of that new sentence under D, providing notice to the person, comma, take the following corrective actions. It's just a phrase inserted right before the beginning of the enumerated list.
Thank you. Member Ely?
I'm just also wondering if state records may have an opinion on how that looks. And with the department not do some of this cleanup of the rule after we're done. I mean, we've provided, if we agree on this and we're providing direction that they need to have written notice, and they could decide where in 604 that is best suited.
I think that's right, Member Ely. So we wouldn't have to work on it now. I think the intent is clear that the board agrees that the notice should be, well, my understanding is that the board thinks that there should be a notice to the person subject of a corrective action. And then the exact location, there'll be one more time where you get to look at this rule again.
Thank you for that. So, Member Garcia, did you have something to add?
I certainly agree with Member Ely. I was thinking the same thing, that records may have a different idea of how to set this up. However, just as a placeholder, just for purposes today, we could call it D, change the other D to E, and then later F, just for a placeholder, and then records can do what they will to correct all this. But I'm just thinking, it just feels funny to say we want that in there and then not say where it goes. But anyway, we could do that.
Thank you. How does that sound to the board? Good on our side? Yes, thumbs up. Okay. Thumbs up from members online. I also agree to that. So we'll address this that way. Member Garcia, how you phrased it last. All right. Okay, I'm regrounding myself here. So that was the proposed language for D by CCAE in their exhibit. Add that language to the rule. And then looking back at the initial proposed, or not initial, but the last proposed version of the proposed rule by NMED was Section D, civil action. And we had some we were discussing some changes to that section. One was taking out costs in that language. And then looking at the enforcement of a compliance order language. So what can we just have some more discussion on that for clarity from fellow board members, what your thoughts are for, and if there's any other revisions? Member Ely?
No, just for clarity. So now D or E, civil action would read, the department may commence civil action in a New Mexico district court in accordance with the New Mexico rules of civil procedure for the district courts to pursue any relief available, including a temporary or permanent injunction, enforcement of notice of noncompliance or settlement agreement, or collection of an assessed civil penalty or fees.
Thank you for that clarity. Yes, legal counsel Ugarte?
Thank you, Madam Chair. Member Ely, just to confirm, I think what I heard you say was enforcement of a non-compliance, notice of non-compliance, and not a compliance action. And that's intentional?
Yeah, that's the verbiage in the rule.
Okay.
From paragraph B, it's notice of non-compliance.
Understood. Thank you.
Does that sound, can you repeat it one more time, Member Ely? I want to make my notes as well.
So D, or the new E, civil action. The department may commence civil action in a New Mexico district court in accordance with the New Mexico rules of civil procedure for the district courts to pursue any relief available, including a temporary or permanent injunction, enforcement of a notice of noncompliance or settlement agreement, or collection of assessed civil penalty or fees.
Thank you for that. So just those details. Board members, any questions, comments regarding that last version? Yes, Member Hunker.
How would a civil penalty be assessed? Other than a prior court action, I guess.
Thank you, Member Hunker, for that question. Legal counsel Ugarte, do you have any thoughts on that or responses?
I'm reviewing, Madam Chair.
Thank you. Yes, Member Ely?
I don't think we know how they would be assessed, but it is one of the possible mechanisms of relief that the department may seek in district court, including an injunction. So yeah, I don't think we know because there's no language regarding penalties in the act.
Yes,
Madam Chair, Member Ely, and Member Hunker, for your question. So I think that's exactly right. What the language says is that the department may pursue. So it's not saying exactly what's going to result. It's just that they may pursue that. And if civil penalties are awarded, then that'll take place, but that has to happen first.
Member Hunker, do you have any follow-up questions, or is that does that address your question?
I'm okay leaving it in there. I mean, I was just curious if I was missing something after spending so much time on all this enforcement language. So I'm okay leaving it in there.
Thank you, Member Honker. Any other comments by board members? Questions? All right, so with that last version, are we, is the board good with the language as read by Member Ely? Yes, thumbs up from Member Bitzer, head nods by folks here. I'm okay with that as well. All right. So we will go on to the next section, which is E or F, depending on the number in the lettering after all of the revisions, will be credit and deficit calculations. Just double checking that what the board sees, if there's any elements here that we need to consider, and given that we've gone through revisions for section 604 above. Yes, Member Ely, you have any comments?
I don't think we need any changes to that.
Thank you, Member Ely. Fellow board members, are you good with that?
I agree with that.
Okay, thumbs up, thumbs up. Great, all right. We made it through 604. Okay. All right, well, that takes us to 605, appeals. And I think we're down to 605B, and we have a proposal by Namoga API AFPM proposed to edit section 605B1A and to delete section 605C below entirely. Any thoughts? Yes, Member Ely?
I agree that we need to delete 605C. I don't agree on the proposed edits to paragraph A there.
Thank you, Member Ely, for your comments.
And if I can elaborate, it
Yes.
just says that what they're proposing is that a person may make a request for an administrative hearing in writing to the department within 30 calendar days of the date of 30 calendar days of the date of a department. And here's the new language they're proposing: engaged in an investigatory action in accordance with subsection A in 604. So a hearing at the point of an investigation doesn't make sense to me.
Thank you, Member Ely. Yes, Member Garcia.
Yes, I agree with that. That's vague to determine when the department engaged in an investigatory action. So I don't think this proposal by Namoga, et cetera, is appropriate.
Thank you, Member Garcia. I see a thumbs up from Member Hunker and a thumbs up from Member Bitzer. So therefore, we would keep the language under NMED's proposed language for section 605B1A. That correct? Thumbs up on our side here in the room. Members in the platform, Member Hunker, Member Bitzer. Okay. And then as for the other suggestion by Namoga API AFPM to delete section 605C. Right, because we took out the compliance order language. Thumbs up from Member Hunker, and agreement here in the room, and Member Bitzer. Okay, we're good with that. Yes, Legal Counsel Agarte.
Madam Chair, I just want to confirm. So C, right now it reads administrative hearing on a compliance order. In the prior section 604, the board revised a provision that referred to compliance order Is that something that would make sense here? I'm just highlighting it given what you did above.
Thank you for that, legal counselor Garte. I'm double checking. See.
So above you revised compliance order, or the reference to compliance order to a notice of non-compliance. So would it make sense to have an administrative hearing at that point or not?
Thank you for that question. Board members, what are your thoughts? As I look at this again. So for those online, since we changed that section, or it would be under notice of non-compliance B. Yes, member Ely?
I know we had a discussion on the 9th about whether there should be hearings related to a notice of non-compliance prior. I mean, we need to allow hearings related to other protests. You know, there were many provisions related to alternative fuel pathways or determining what the EER may be. There are many opportunities to protest a decision by the department that are not enforcement related. But do we want to have a hearing if there is a protest on a notice of noncompliance?
Thank you, member Ely. Thoughts by the board? Member Garcia. Oh, not yet. Oh, member Honker.
I'm just thinking that could be a lot of hearings because, having run enforcement programs, the number of notices of noncompliance versus the number of orders issued is a very different level of action. So it just sounds like it could be generating a lot of additional hearings.
And I'm throwing this out there. So since we changed compliance order to correct that section to corrective actions, could it be corrective actions? Or is that just to your point, member Hunker? I'm just throwing this out. To your point, member Hunker, is there's a lot, probably, order or notices of non-compliance, and then the compliance order, which is the action being taken. I mean, where there has to be action on behalf of the regulated party. So I'm wondering if, because in our new section C, corrective actions, there's items there or actions taken listed there, like suspend, restrict, modify, revoke an account, suspend, modify, delete approved alternative field path, suspend, restrict, and cancel credits, recalculate deficit, all of those 1 through 5, or mainly 1 through 4, but or 5, any action the department has authority for elsewhere in the rule. And I'm just throwing that out there if the thoughts, since we changed that section. Yes, Member Ely?
You know, it seems like there should be some avenue to protest these, but I agree with Member Honker that it could be pretty burdensome to have an administrative hearing on notices of non-compliance, but potentially there could be a hearing on corrective actions. So if you're going to suspend somebody's credits, or you're going to delete their approved alternative fuel pathway, seems like they should have some kind of avenue to protest that.
Yes, because right now, as the rule stands, without going back, if we deleted that, or if that wasn't an option for the regulated party, what would be the way that they address if they don't agree with the corrective action taken? It'd be civil action. Everything would be under civil action. So what are the thoughts of I mean, initially there was the compliance order section, and that was this what we're talking about, the language then referred to that section. And that could also be burdensome too on the regulated party to have to go through the filings under civil action as well. Yes, Member Garcia?
Yes, I agree that it would be incumbent on the department to allow due process of protesting or appealing somehow that action, and then if there's a decision by the secretary, that decision would then be appealed to court, to district court.
Correct. And I know NAMOCA, as a regulated party, wanted or suggested to delete section 605. Let me look at there. But I think it was in relation to deleting the compliant, taking out the compliance order section. So then that would have resulted. So I think, let me go back to their final submittals. Give me a second. Oh, they don't address 605. Okay. Yes, Member Garcia.
On the NMED suggested changes, the most recent on item number 7, if protests are allowed but appeals of the protest not allowed, revisions to 605A5 are necessary. The person may request an administrative hearing on the department's decision on the protest by following the process, blah, blah, except not in the protest, not if the protest was in notice of noncompliance. I don't quite.
Thank you.
Sounds like they're agreeing with us that potentially there shouldn't be administrative hearings for notices of noncompliance.
And what was that reference, Member Garcia?
This is on the suggested fixes that the department provided, and on the very last page, item number 7.
Okay. Okay. Yes, Member Ely.
I'm going back to CCAE Exhibit 4A, and they have a very much different looking section on appeals, but there's language that might be helpful. It says any person that is subject to an ACO, we would take that out. So it'd be any person that is subject to a corrective action by the department may appeal the order on corrective action by filing a request for a hearing under subsection A of section 20.1.5 200 NMAC. The hearing will be governed by the department's adjudicatory procedures 20.1.5 NMAC, except that the corrective action shall be treated as a permit suspension or revocation under 20.1.5. I'm not quite sure what that language looks like, but they do offer some language to propose an appeal for a corrective action in their Exhibit 4A.
Thank you, Member Ely. I'm getting to Exhibit 4A. Yes, Member Garcia. It's in our record.
It's in the docket. I might have it here.
Okay. Thanks.
So, Member Ely, just for everybody, and just to point back to our docket and record, we're looking at CCAE Exhibit 4A, and it's in their version, their proposed version language, it's C if the corrective action restricts that language.
No, it's Exhibit 4A, an exhibit that was presented during direct testimony in the docket, and it's 605 under appeals.
Oh, got it.
Okay. I have a hard copy if you'd like to look at it.
Yes, so for member, I have it right here. Yeah, I got it now. So for board members on the platform, if you are looking at your docket, it's
It's
hard to find things in the document.
I know.
Yeah, it's page 84 of Exhibit CCAE Exhibit 4A, and it's under section. In that exhibit, the title or the enumeration is 20.2.92.604 appeals.
And what was the date of that?
This one.
I tried to find it.
So
Oh,
it's for
it's
under
it, yes, it's under the direct testimony, and it's CCAE's exhibits, and I label mine 1 through 8 because it's exhibits 1 through 8 in that PDF. And but under exhibits 1 through 8, it's specifically Exhibit 4A. Under 4A, it's page 84, if that helps.
So hard to find.
Yes. So, are you there? Okay. So we have under that section, as Member Ely helped us find this section, as she read it, it starts the paragraph, any person that's subject of an administrative compliance order or corrective action by the department may appeal the order or corrective action by filing a request for hearing under subsection A of section 20.1.5.200 NMAC. And then it goes on, the hearing shall be governed by the department's adjudicatory procedures 20.1.5 NMAC, except that corrective action shall be treated as a permit suspension or revocation under 20.1.5 NMAC. So it looks like we would have to look at this language if this is the basis or template. Sorry. And this would therefore be just reiterating to address in NMED's proposed section 605, 605, under appeals, 605C, which is in the final proposed administrative hearing on compliance order.
So it would replace that.
So it would, this language will replace that under that. Yes,
That
Member
sounds
Garcia.
good to me.
Well, I think we would need to amend the CCA language. It refers to a compliance order. We would have to take out compliance order and
Replace it with
just leave
corrective
in the
action.
corrective actions. Yes, Member Ely?
I'm just looking up the language they reference in 20.1.5 regarding permit suspension or revocation, just to make sure we know what we're talking about. I wonder if we should take a break. Is it time to do that? And we can dig into this a little bit.
Okay, we can. What are folks online, board members online? What's your thought? Thumbs up by Member Bitzer, Member Honker, and Member Garcia. What are you thinking, fellow board members? 10 minutes? All right, so let's actually come back at 11:35. Thank you. Yeah.
But
she can't.
But I can't see them.
It's a red light on that phone.
Yeah, so it's okay. I can go to the side. I'll go to the side. I can't see the board. Thank you. All right. I can see everybody now. Good. We're back here. And actually this actually might be better, Pam, so it's okay. All right. So where we ended, we are at our 605 section. We are looking at new language regarding appeals. And so I don't know, Member Ely.
Yeah, just our council pointed out that, hey, you know, the language that already exists in C, 605C is probably best to work from that. And that looks a lot like what is in CCAE's exhibit. And so if you go to the rainbow version 605C, instead of saying administrative hearings on a compliance order, you could say an administrative hearing on a corrective action, and then replace compliance order with corrective action in the rest of that paragraph in 1 and 2. Shall I read it?
Yes, can you read that,
Yeah.
please?
So it would be 605C, administrative hearing on a corrective action. 1, any person that is the subject of a corrective action by the department may appeal the corrective action by filing a request for a hearing under subsection A of 20.1.5200 NMAC within 30 days of the date the department issued the corrective action. 2, the hearing shall be governed by the department's adjudicatory procedures in 20.1.5 NMAC, where the following applies. Act means the context requires Section 70-1-18 NMSA 1978 of the Environmental Improvement Act, and B, corrective action means a corrective action issued by the department pursuing to subsection C of 20.2.92.604, and regulations means 20.2.92 NMAC.
Thank you.
And so I do think that meets our intended objective, which is to ensure that there is some recourse on corrective action for the regulated community if they're unhappy with it.
Thank you, Member Ely. I see some head nods from Member Hunker, Member Bitzer, Member Garcia. So with that latest version, as for administrative hearing on a corrective action, section that was just read. So I think we just here looking for thumbs up on this last version. Are we good? Okay. Thumbs up, we're good. So wonderful. That gets us, yes, Member Ely.
Before we leave that, there is, Member Garcia brought up the issue in 605A5 that the department is proposing, except to add some new language to that. If we're not doing protests on notices of compliance, I don't know that we had a discussion around that. So if you go to 605A5, and it reads, the person may request an administrative hearing on the department's decision on the protest. Person may request an administrative hearing on the department's decision on the protest by following the process in subsection B of 20.2.92605 NMAC, except not if that protest was of a notice of noncompliance.
Okay. So it'll be after NMAC, comma, except, say that last language again.
Except not if the protest was of a notice of noncompliance. And that conforms with our discussion that we wouldn't have protests related to a notice of noncompliance.
Thank you for that, Member Ely. Fellow board members, want your thoughts, if you have any questions, comments, discussion on. Nope. All right. So we have head nods here. I'm good with that language, and I see that how that would benefit and kind of address those all the revisions that we're doing here to this section. Thumbs up from Member Hunker, Member Bitzer, yes. All right. I'm good with that. We're good with that addition in that part of the latest version of the rule. All right. Thank you for that, Member Ely and Member Garcia, for pointing that out. And so we are now going to section 700, 701. So right now we have 700 reserved. And again, we have the tables in 701. Members, are you, I know we got 9 minutes before noon. Do you want to delve into this, or what are the thoughts of the board? Yes, Member Garcia?
I think this is the last piece, so I think we can go ahead and finish this. I don't see that it would be necessary to change any of the tables, in my opinion. So I think we could probably finish, unless somebody else wants to, I think we could probably finish this before lunch.
Thank you. Yes, Member Ely?
And I would like to go to when we're all done, go to CCAE's motion regarding limited use of revenues related to vehicle manufacturers' sale of credits. If you saw that motion, they're asking us to reconsider that, and I would like to at some point. Yeah.
Okay, discuss that. Okay. And just noted the record, I got a message from Madam Hearing Officer Orth, and she had another commitment right now, so she won't be back on till maybe 1:30, 2 o'clock. So just sharing that information with the board. So let's go through this section here, make sure that we're good on the tables. As I go, table 701A, table 1. I don't see any changes to that. Table B. All right. Table C. Yes, Member Ely.
Madam Chair, I went and I looked at each of the proposals, from NMOGA, from CCAE, from the biofuels folks and Sinclair. And, I didn't see in my mind a need for any changes based on previous discussions related to retention of EER, retention of ILOC, no change in how the carbon intensity would be reduced over time. So just before we go into it, I'm of the same mind as Member Garcia that after looking at all their proposed changes, I kind of think we should reject all of them based on previous discussions. But it may be good for the record to have an individual discussion on each table. I don't know what your feeling is on that.
Thank you for that. And thank you for pointing to our previous discussion. I know we had a few days before between our initial start to the deliberations to where we are today. So just thank you for highlighting that, Member Ely, to put that in our discussion. So we could maybe note that, and that will also help our Madam Hearing Officer and us and legal counsel all know that we are considering and looking at each table to have a basis or justification for each one, that we note that in our discussion. So with that, board members, so table 1, this is the New Mexico Clean Transportation Fuel Standard for gasoline and gasoline substance. This has the carbon intensity % reduction. And I know NMED have provided some reasoning here as well. So looking at that, are those notes in our multicolored version, I see that, and then also pointing to evidence in the record and material submitted. Member Ely?
So on table 1, NMOGA proposes that we change it and use their values that were based on R&D GREET, not New Mexico GREET. We've already had a discussion that we're going to stick with New Mexico GREET. It also proposes to delay the generation of deficits, and we had a discussion that we would not be doing that. Sinclair is similar, though they have a different reduction trend, but we've already agreed that we're not going to change that. And same with CCAE, they're proposing changes after 2030, and we agreed that we weren't going to change the declination of carbon intensity after 2030. And then Rio Valley Biofuels has some proposed changes that also don't seem to include the latest New Mexico GREET number. So I support not making any changes to that table based on our previous discussions.
Thank you. Yes. Thumbs up, thumbs up. Agree to keeping the table 1 as last revised and proposed by NMED with and also looking at our previous overall discussions from a few days ago as well as the basis. All right, let's go to table 2. And this is New Mexico Clean Transportation Fuel Standard for diesel and diesel substitutes.
I suppose we reject any proposed changes based on the same justification. It's not based, some of these changes are not based on New Mexico GREET, and they propose different delays to the carbon intensity, and we've already agreed not to do that.
Thank you, Member Ely. I see head nods in the room and thumbs up online, thumbs up from Member Hunker and Member Bitzer. I also agree with keeping table 2, this last version. Table 3, which is fuel crediting benchmark for alternative jet fuel based on the carbon intensity of conventional jet fuel. Any discussion, Member Ely?
I just propose, again, no change. It's not based on New Mexico GREET, and we're going with the New Mexico GREET value for that.
Yes. Thumbs up online from Member Honker. About you, Member Bitzer? Yes, 2 thumbs up. All right. And yes, Member Ely wants to comment.
And just to add for the record, CCAE wants to reinstate the initial proposed declination in carbon intensity for alternative jet fuel, and we've already rejected that proposal.
Thank you for that, highlighting that, Member Ely. And then again, that was part of our discussion previous days of our deliberation. All right. So now we are on table 4, New Mexico statewide fuel path lookup table. And please take a look at that, fellow board members. And this goes over fuel path descriptions and carbon intensities. Any comments from board members on this? Yes, Member Garcia.
Yes, we did have a fair amount of discussion about the lookup table, and we decided to leave the values as they are and to be more consistent with other jurisdictions. I propose we leave the table as is.
Thank you, Member Garcia. I see a thumbs up from Member Honker and Member Bitzer and Member Ely. I also agree with keeping it as is, as proposed by the department. Table 5, New Mexico temporary fuel pathways, and this is again regarding carbon intensities with the margin of safety. Any discussion, thoughts?
Yeah.
Yes, Member Ely?
For this table, NMOGA is proposing to do away with the temporary fuel pathways, and we're maintaining the temporary fuel pathways. So we want to keep that as is. Also, Sinclair as well. And their change numbers are not based on New Mexico GREET, so we need to reject that for that reason as well.
And then also they just want to also note the growth energy proposed to changes based upon their proposal regarding the ILUC and the ILUC values. In previous discussion last week or a few days ago, we and please correct me if I'm wrong, board, we decided not to incorporate growth energies proposals. Okay. Yes, I see thumbs up. So we will therefore leave, yes, Member Ely.
Oh, just Rio Valley Biofuels proposed some changes that the department has already incorporated. So we don't need to worry about that.
Thank you, Member Ely. So with that, we would keep table 5 as proposed by the department. And thumbs up for that. Are we good in the room? We're good. How about board members online? Member Hunker, thumbs up. Member Bitzer, thumbs up. And that takes us to table 6. Summary checklist of quarterly and compliance period reporting requirements. Yes, Member Ely?
So NMOGA is proposing to eliminate EER, and we're not doing that. We're going to maintain EER. And so let's see. Yeah, so Clara didn't, but yeah, so I propose that we maintain that because as written, because we are keeping the EER provisions in the rule.
Thank you, Member Ely. So seeing some head nods here in the room, thumbs up online. We will be keeping table 6 as proposed by the department, noting some of our previous discussions regarding, in particular, EERs and the board's decision regarding that as well, and keeping EERs. So that takes us to table 7, New Mexico energy densities of transportation fuel types. Yes, Member Ely?
Industry proposed eliminating that because they're proposing R&D GREET, and we're keeping R&D GREET. That table is essential for NM GREET. And that table is essential for doing certain calculations for reports that need to be submitted, so we need to keep it.
Thank you, Member Ely. Board members, are you good with keeping table 7? Thank you. Also, based upon our previous discussion regarding NM GREET versus R&D GREET, and keeping NM GREET as the basis. That takes us to table table 8, New Mexico energy economy ratio values. Yes, Member Ely?
So NMOGA proposes eliminating that. Of course, we agreed to keep that. CCAE wanted to change the value for electricity, battery EV plug-in hybrids. And we had the discussion that we were going to maintain that value as proposed by the department. So I suggest no changes to that table.
Thank you, Member Ely. Fellow board members, are you good with that? Great. Thank you. Thumbs up online and agreement here in the meeting hall. And that takes us to table 9, indirect land use carbon intensity values of specific fuel feedstocks. Board members, Member Ely?
Yeah, so industry would like to eliminate that. We already agreed we're going to maintain those ILOC values. And CCAE would like to change the value related to palm oil ILOC, but we also rejected that. So I support no changes to table 9.
Thank you, Member Ely. I agree as well. Member Bitzer and Member Hunker online also agree. So we will be keeping table 9. And that takes us to the end of our edits. And then we have the discussion that you noted. Member Ely?
So CCAE filed a motion that we reconsider how credits generated from vehicle manufacturers are used. We had some discussion about whether there was the authority in the Act to do that. The Act specifies that EDUs have restrictions on how they use those revenues, and but it was silent on vehicle manufacturers. CCAE proposed that we actually do have the authority to allow to limit those, how the revenue from the generation of those, from the sale of those credits is used. And in a sense, they're saying the reason the authority is there is because it's not a mandated program, it's an opt-in program. So manufacturers may come into the program, but they're not required to come into the program. And then if they do come into the program, the revenue from the sale of those credits then must be used in a certain way to promote EVs in New Mexico. You'll see that on the docket. It was, and Pam also sent that out yesterday afternoon. If you want to take a look at that.
Thank you, Member Ely. Just making sure all the board members see what Member Ely is referring to. And this was the one submitted January 15, 2026 from Coalition for Clean Affordable Energies for reconsideration in response to hearing officer's message. Making sure everyone sees that.
So we had already, which section in the rule is this?
Section 305.
So look at section 305. And then also collateral connection to section 403C, 305D and 403C in the proposed rule. Let me go back. Yes,
So
Member Garcia?
Just to get us on the same page, we proposed to completely strike all of D, 305D. So now it's a matter of reconsidering if we want to accommodate CCAE's suggestion.
Yeah, are we persuaded that we actually do have the authority in the enabling statute to retain this provision?
This was the section, right? Section 5 in the statute. Yeah, that's right. Okay.
Sorry, I'm trying also to get there. All right. Okay, finally got there. Yes, Member Ely.
And if we don't believe we have the authority to do that, then they're suggesting we revise 403C to give utilities and backstop aggregators credit priority, because they will be using the money in a way that promotes clean vehicles in the state, and allow vehicle manufacturers to obtain credits for residential EV charging that those other entities don't claim. So if there's anything left over, they get it. Otherwise, that's not the case, and they would not have to use that revenue in state to promote clean vehicles in New Mexico, or EVs in New Mexico.
Thank you, Member Ely. Any other thoughts, comments?
I was just wondering if our council had any thoughts on that, about the case made by CCAE on legal authority.
Thank you, Member Ely. I think generally speaking, as we discussed before, the board is empowered to develop a cohesive rule. If, as you pointed out at the beginning of this discussion, if electric vehicle manufacturers' participation in the program is voluntary, then volunteering to participate in the program comes with requirements, like many of the other requirements in the rule. And so if one of the requirements relates to the expenditure of the credits, then they're informed ahead of time. So it seems to me that it's not unreasonable.
Thank you, legal counsel, Ugarte. Member Bitzer, I saw your hand up, or you were unmuting earlier. Do you have a comment?
I was going the same direction as Member Ely in terms of checking in for a reminder from council.
Thank you, Member Bitzer. And thank you, Mr. Ugarte, for sharing your thoughts. Any other thoughts, discussion, Member Ely?
I would be comfortable reconsidering our vote from, I think it was on the 8th, and going back and including vehicle manufacturer restrictions related to how they use the revenue from sales of credits.
Thank you, Member Ely. Member Garcia?
Yes, I would also like to see the money spent that would benefit New Mexico. So I'm wondering if making the change in 403C that CCAE is suggesting would, creating the backstop aggregator or acting as a backstop aggregator, would that take care of that? Would that help that regard?
It would help.
So maybe we could do that.
Thank you, Member Garcia. So we'll be changing 403C in lieu of adopting Section 305D as in dog. Is that what you're suggesting, Member Garcia? Okay. She's saying head nodding yes. So let's take a look at 403C. All right. Any thoughts from fellow board members on that language in 403C to ensure that credit revenue generated from residential electric vehicle is invested or maybe providing some details on that within the rule?
So the CCAE is not proposing particular language. They're just suggesting that we revise 403C to give utilities and backstop aggregators credit priority. So I'm just trying to figure out how we put that into the language.
Thank you, Member Garcia. Yes, Member or Legal Counselor Gott.
Madam Chair, and both Member Garcia and Member Ely. So as I understand it, you're now focused on the question of how to ensure that the vehicle manufacturers spend these credits in New Mexico. So not only did they have to, for the purpose described, but then the location. Is that correct? Is that the,
Yes, Member Ely.
The way I think 403 is, or what CCA is proposing is that just fewer credits would go to vehicle manufacturers and more would go to EDUs and backstop aggregators. So if we just look at 403, I think that's the intention there. I think it might be easier just to retain 305D.
Say that last part, Member Ely. I missed it.
I would support not messing with 403 and just retain 305D.
Okay.
Yeah.
Um,
Which would place the limits on how the revenue from sales of credits is used. Yeah.
okay.
And again, if it's an opt-in program, they don't have to do it. They don't have to generate credits and sell credits. But if they opt in and decide to do that, then the restrictions related to that revenue are in that paragraph.
Right. So if they opt in to following the rules. If
Yes.
we can frame it that way.
Yeah.
Yes, Member
Okay,
Garcia.
I'm fine with that. We had determined that the statute didn't authorize 305D. But if we want to keep it, I'm okay with that.
Board members online, I hope the discussion was clear. So I know we had discussed our authority and there wasn't in previous and whatever, a couple days ago, weeks, we had discussed the limitations that we were concerned about our authority, but with I guess perspective of we're not regulating the EV like or we're not regulating but them only if they opt in. They're not required to. Yeah, so this isn't just a blanket. It's only if they opt in per language. And I'm seeing nods in the room, trying to make sure I say it appropriately. What are your thoughts online? Thumbs up from Member Bitzer. What about Member Hunker? Do you have?
Yeah, I don't feel strongly on this one. I'm fine to put it back in.
Thank you, Member Hunker. So if we make a decision to keep 305D as in dog, then we don't need to amend 403, correct? Okay. Are you also good with that, Member Hunker, Member Bitzer? I know. Thank you. Thumbs up. All right. Thumbs up in the room as well. All right. Any other thoughts before we address? We're at the end here. So just making sure, yes, Member Garcia.
One other item NMED brought up was in eliminating 604C, there were several sections, probably 8 or 10 sections of the rule that refer to 604, but I think Member Ely already mentioned that it just says 604C. So I think what we changed won't be a problem for all these sections. I think it'll work. So I just wanted to address that.
Okay,
particular
so
issue.
to know, I think, and please correct me if I'm wrong, Member Ely, you mentioned that it was brought, the reference section was 604 and none of the lettering in the proposed rule.
Yeah, I went back and looked at all the references that they pointed out, and indeed, it is 604. So, and even if it wasn't, they could go back and when they do the cleanup on the rule, add the lettering, but it is just plain old 604. So I think we're good on that.
Thank you.
Okay, great.
Thank you, Member Garcia. Member Hunker, Member Bitzer, do you have any other items that we might need to consider before wrapping up deliberations? Member Garcia, do you have anything else?
If I could ask council if we need to make any grand final statement about the rule, approving the rule with the amendments we made.
Member Garcia, the board will need to take a vote on the final rule as been amended. And so I'm wondering if, so that'll be the final, these are just preliminary checkpoints along the way. It's up to the chair, given the time, whether you want to do that now or you want to wait till after lunch, just from a logistics perspective.
I think we do it now so we don't, since we're on a roll here with this particular deliberation, and then we can have a good lunch without opening cans of worms again when we come back.
Okay.
All right. All right. So the overall motion, I know want to make sure, and we'll probably need your input, legal counsel Ugarte, but because we're gonna have to make overall motion for the rule adoption as we've been discussing the language and the details. So I'm looking to fellow board members. I know in the past we've done a motion and then that captures it. So I don't know if anyone wants to take a shot at it. Yes, Member Garcia.
Thank you. I will take a shot at finalizing our decision. So I would move that we adopt the Clean Transportation Fuel Program Rule Part 92 as amended by the board. That's it.
Is that sufficient, legal counsel Ugarte?
Madam Chair, so I think Member Garcia, I think it's fine. I think maybe just to add at the end, as amended through these deliberations.
Okay, I would revise my motion to say we approve the rule as amended by these deliberations based on the evidence provided in the hearing record.
Thank you that you were reading my mind.
I'll second that.
Thank you, Member Bitzer. Yeah, and Member Garcia read my mind as evidence in our exhibits. It's been a long, so making sure. So we'll do this motion, just since we have a motion on the table and then a second. We'll do this motion. Do we need to do a subsequent motion to capture like all of the typographic, anything else that, or should we just capture it in this motion? Legal Counsel Ugarte?
Madam Chair, I think Member Garcia's motion captured that all.
Wonderful. Okay, thank you for that point of clarity. Is there any further discussion, fellow board members? Member Garcia's motion and Member Bitzer's second? If not, Ms. Jones, please do a roll call vote on Member Garcia's motion.
Member Bitzer, how do you vote?
I vote yes.
And Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
I vote yes.
And Chair Sweeney?
Yes.
Motion passes.
Thank you, Ms. Jones. Appreciate that. And I just thank you, everybody here, legal counsels, the parties, the entities that have been involved in the process for EIB 25-23R. A lot of hard work, a lot of long hours have gone into this, and appreciate your also grace and patience, as I said at the end of at the recess of deliberations a few weeks ago. So thank you all, and thank you. We're at a point. Yes, legal counsel, Ms. Sona.
Thank you, Chair Sweeney. As Chair Sweeney just stated, my name is Kelsey Sona. I'm legal counselor for the New Mexico Environment Department on the rulemaking. I just wanted to flag the legal brief that was filed regarding the effective date and the filing deadlines for the New Mexico Register to get everything adopted in time as your counsel and the hearing officer work towards a final rule, final order, and those things. The department stands ready to assist with those technical pieces to get it across the finish line. So thank you.
Thank you, Ms. Sona, for that, and I appreciate you highlighting that. I'll be coordinating with legal counsel Ugarte and others, Ms. Jones and other support to make sure that we take all of those milestones into consideration. And thank you for pointing that out, Ms. Sona. All right. Well, with that, I think we can go to lunch and come back and have Mr. Curry, Member Curry, and Member Carrasco, if you can get a message to them that we'll be coming back. Well, I don't know if they could participate that because we have already that was we will be considering the approval statement of reasons in the regional haze matter. So legal counsel, what are your thoughts on that?
Madam Chair, I'm not clear whether the two members have decided to participate in that part of it. I would imagine not. But
Yeah, they haven't verbally said, but I know that they were not part of the hearing nor deliberations.
Correct. Yeah, I would expect they wouldn't be, but I obviously can't speak for them.
Okay. Okay. Well,
we could continue, I suppose.
If Member Carrasco and Curry are not going to participate in the discussion on the statement of reasons, I wonder if we could just finish up for today.
okay.
Yeah.
I mean, we'll finish it up today. I don't know if you wanted a lunch break or you're good with continuing.
It shouldn't be more than another half hour, I think.
Okay. What about folks on the platform? Member Hunker, Member Bitzer, thumbs up, thumbs up. Okay. I'm good with that as well. And just note, Madam Hearing Officer is not available till 1:30. That's the other consideration. if we have any questions from Ms. Orth. We could take a lunch break and then okay. So sorry, I forgot to add that earlier. So what we're gonna do is take an hour break, and that will hopefully will give time for Ms. Orth to get back on the platform. Thank you so much. See everybody at 1:30. All right. All right, board members, we are back from lunch and we are on agenda item number 6, which is EIB 24-49R, discussion and approval of statement of reasons in the matter of Regional Haze State Implementation Plan revision for the second planning period and the proposed companion rule 20.2.68 NMAC regional haze requirements. All right, so we do have a statement of reasons, and I just want to open up the discussion to board members. I think there was some question about some text in the statement of reasons. Yes, Member Ely.
I think the hearing officer did a good job of summarizing our conversation, our deliberations around this. Her body of work includes the statement of reasons from the department, and they made an error, almost a typographical error, but anyways, on page 205, paragraph 421, they refer to El Paso Natural Gas's facility, Chaco gas plant, and that's incorrect. Enterprise is the company that owns Chaco, so I would suggest just replacing El Paso Natural Gas with Enterprise way back in the document. Page 205, paragraph 421.
Yes. Do folks see that? And if just checking in, Member Hunker, are you back online? Sorry, I didn't check that. There you are, Member Hunker. All right. So we're looking at the statement of reasons, and Member Ely pointed out. Is there any questions regarding discussion? All right. All right. Yeah, seeing none. I think I'd love to entertain a motion. Yes, Member Garcia.
Yes, I would move that we approve the statement of reasons for EIB 24-49R, the Regional Haze Implementation Plan Revision 20.2.68, and include the rule 20.2.68 as approved, with the change that Member Ely, the correction Member Ely pointed out.
Thank you, Member Garcia. Thank you, Member Bitzer, for your second. Any further discussion? Oh, okay. Sorry, I was looking at that chat, but it's not pertaining to this. All right. With that, Ms. Jones, would you please do, or Luis, Mr. Lopez, sorry, Mr. Lopez, please do a roll call vote on the motion.
Yes. Okay. Member Ely, how do you vote?
I vote yes.
Member Garcia
Yes.
and Chair Sweeney.
Yes.
Member Bitzer.
I vote yes.
Thank you. And Member Hunker.
Yes.
Thank you. Motion passes, Madam Chair.
Thank you, Mr. Lopez, and thank you, board, for getting the statement of reasons for Regional Haze done. I think that takes us to the next agenda item, which is agenda item number 7, next meeting and other business. Is there any, I know we've had a lot of activity. We've had our deliberations, meetings. Is there, Ms. Jones, can you remind us what's next coming up?
Yes, the next meeting in February is the 27th, but that is the end of the first week of the PFAS hearing. So that really the next thing for the board is EIB 2561, which starts on February 23rd and runs through March 6th.
Yes, Member Garcia.
Yes, thank you. I'm not going to be able to attend that one. I'm going to be out of town for much of it. So fortunately, we have new board members, so I think it would be okay. I'm going to skip that one.
Okay, and that will be, can you remind me what that's not the PFAS, that's.
Yeah,
That
the
is PFAS.
EIB 25-61 starts February 23rd, goes through March 6th.
Right. Making sure I put that in my calendar. So that's a 2-week.
Mm-hmm.
Okay. All right. And then, so that's a hearing.
That's a
correct?
hearing. It's in at the Roundhouse from 309.
Okay. So we have that one. That's for the hearing. And sorry, I'm coming back from lunch. My brain, I think, is still at lunch. So after, in that time frame, are we going to have a regular meeting? Is that what we have scheduled?
Well, it starts on Monday the 23rd. Your regular meeting would be Friday the 27th. So we could start with a business meeting prior to the hearing starting on the 23rd, I guess. You still need to elect officers and such, but
Correct.
Council Ugarte, can they do that maybe in a March meeting? Or I don't know how, or in OMA, can it go much farther down the year?
Ms. Jones, yes, I mean, the board can move it but they could also at the beginning of the 23rd do the meeting at that time.
Okay. And then, so I just want to also note for the board and for the timelines, when we'll have the statement of reasons for the Clean Transportation Fuels Program, so that we can vote on it as a board. Mr. Ugarte, do you know if, I don't know if you've touched base with Madam Hearing Officer or for how when we could expect that?
Madam Chair, no, we have not discussed and we can connect on that after the meeting and let you know.
Okay, and best case scenario, so that we would have it so that we could vote on it on the 23rd, but you're not going to be here, right? Member Garcia? Okay. Yeah. Are you it's trying to.
Well, you have, so that hearing goes through March 6th, Friday, March 6th. Then on, excuse me, Monday, March 23rd, we have the operating fees hearing. That's EIB 2577. That's the 23rd to the 25th. And at the end of that week is what your regularly scheduled meeting, but I don't know if you want to meet twice that week.
Okay. Can you repeat that date?
The date of the operating fees hearing is March 23rd to the 25th. That's a Monday through a Wednesday.
Yes.
Madam Chair? I'm just looking at the deadlines that the department put out for us, and we need to make sure we meet those for an effective date of April 1. And the earliest final order is February 13th. That's what they put in.
Say that again, the earliest final order, or that's when we need to make a decision on the statement of reasons and the final order by? Just remind me.
I'm not sure.
Oh, okay. I know this was provided as part of the correspondence in preparation for deliberations. Okay, to ensure proposed new rule 20.2.92 NMAC have an effective date April 1. Last possible publication date will be March 24th. Last possible stamped deadline is March 2nd. And then, okay, which then we go back, earliest final order 15 days prior would be February 13th.
Yeah.
Which is a Sunday. Thus, if the board adopts final order on February 13th, which is the Friday before the 15th, then the department must file publications in the New Mexico Register no later than March 2nd. So it looks like, I'm not sure if this was a typo, but it says earliest final order in this, but I think they might have meant last possible final order date. The filing deadline. Okay, let's see. The filing deadline is earlier than the March 12th deadline set by the commission because it must be at least 30 days before the effective date of the rule. The department's preference is not to wait until this last possible date, but to file with the commission as early as possible. If the board adopts a final order before February 13th, then the department must file for publication in the Mexico Register no later than 15 days after the date of adoption, unless the filing date is Saturday or Sunday, in which event the time is extended until the end of the next day, which is not a Saturday or Sunday. So if the board makes changes to the proposed rule, then the process may take additional time for state records, administrator, and commission to review the language for corrections. Let's see. So, okay, deliberate no later than Thursday, February 26th, where we've met that. Okay. So with this, thank you for this, Member Ely. I know this was shared with us. So it looks to me like the department is hoping for somewhere around February 13th is what I see. So even our next time we're together, February 23rd, that might be too late. So I'm glad we're talking about this. So can we find a date? What does February 13th look like? Okay. What about you, Member Ely? And Member Bitzer, Member Hunker? Yeah. What about you, Member Bitzer?
February 13th. Yeah, I'm good. February 13th.
Okay. Okay. Um,
13.
yes. Is this something we could do virtually? That might be, what do you think, Legal Counsel Garte or Ms. Jones?
The guidance in OMA is that a public body may meet virtually if it's difficult or impossible to meet in person.
Okay. So I have a meeting down in Albuquerque at 9, but and usually that's 9 to noon on that day, and regarding another some ongoing legal matters with water for the state. So the 12th looks good for me. What about others on February 12th? Yes. Oh, great. Great idea. Yes, I can do 9 a.m. February 12th. All right. Yes, so that would be the report or the statement of reasons, legal counsel Garte with Miss Orth. Do you want to reach out to Madam Hearing Officer Orth? I know we had a lot of things that we went over in our previous days of deliberation, and I thought she had indicated she was already working on it.
Well, yes, Madam Chair, we'll connect and we'll know now that the target is to get it that week.
Okay, thank you.
And where did we land on virtual or hybrid?
We'll be meeting hybrid, so in person, and then if some folks have to be virtual,
All
that'll
right,
work.
I'll get a location.
Okay. Thank you, Ms. Jones. So put that on your calendars, and Ms. Jones will identify a location for the consideration of the statement of reasons for the Clean Transportation Fuels Program.
And did I hear correctly that we're back to the 13th on that?
We're February 12th at 9 a.m. Is that good with you, Member Bitzer?
Yeah, that'll work.
Sounds good. All right. Well, I'm glad we talked through that, and appreciate the references, Member Ely. And is there anything else for us to consider, Ms. Jones, administratively, logistically, with our upcoming meetings?
No, no, Madam
Oh,
Chair.
okay. Thank you. And again, thank you all for your support in all of this and marking calendars and such. Is there anything else? Nope. All right. Well, I'd love to entertain a motion for adjournment.
I move that we adjourn.
I second.
Thank you. And I think we can do a quick roll call on that motion.
Sure. Member Bitzer, would you like to adjourn?
I would. Yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Thank you. And Chair Sweeney.
Yes.
Meeting's adjourned.
Thank you. Thank you, everybody. Have a wonderful rest of the day.